let's go back to where we left off. There's some stuff coming up now that we have not talked about. License requirements. I'm on the second page, I think, of the second page of the notes. In order for you to get it, you have to complete a written application and pay $100. That's the application fee. You have to be 18 years old. You have to have good moral character, provide a background check. By the way, if you haven't done your background check, start looking into it, start getting it done. It could take a little while for it to get back, particularly if you've had multiple places you've lived in the last 7 years. All right. Sometimes it comes back in 48 hours, sometimes not. So just a heads up on that. No citizenship or residency required. You do need a green card. Yeah, background check is in the relink book. Thank you, Cassie. Appreciate that. Right. You can go to the website and go in the application. There's a link there. There's also how to get a background check through the relink book, which we've gone over. We're going to pass this test. We're going to pass this class. All right. And then the state test, the state licensing exam. You do have to have a social security number. That you have to have. And if you're going to be an LLC or a corporation, you need to have a firm license also. If you're a sole proprietor, you don't need a firm license, okay? But your broker in charge, if you're working with somebody, they have to have it. Okay, license requirements we keep talking about, right? All right, social security number, firm license if you're going to be one. You don't need one to be a sole proprietor. All right. Now, let's talk about inactive license here. All right, this is something that you need to know. You can request your license that you're going to get as a provisional broker is going to be inactive. So your broker in charge is going to have to activate that license. Okay, so you're going to have to find a broker in charge who's going to take responsibility for you. All right. Even as an inactive license, you still have to renew it each year or your license is going to expire. Okay. And if it expires, we'll get to what happens. Provisional brokers will go inactive automatically when not under a supervision of a broker in charge. You're going to get an inactive license, right? You have to be working for somebody. You have to update your continuing ed for the current year to return to active status if inactive since previous July 1st. So let's say you don't, let's say on June, say you have a license and you're not in your provisional year. On June 30th, you don't do your continuing education and you go inactive. In order to activate your license, you have to do that continuing ed plus when the next year is going to come up. All right. You have to do both. All right. Now, if you're inactive for less than 2 years, you have to do 12 hours of CE plus the current year update class. All right. So you're going to have to do, so that comes to what, 16, right? 2 years of 8 for 1 year, 8 for another. All right, if inactive for more than 2 years, then the current year's CE plus an update class and 2 post-license classes completed no later than 6 months prior to activation. So you're going to have to do 2 of those post-license classes again, all right? So you have to do those if it's more than 2 years. Now, all licensees have to complete 8 hours of continuing education each year prior to June 10th to renew and keep their license active, beginning with their second renewal. Why? Because you're in what? You have a provisional broker's license for that first renewal. All provisional brokers have to complete 90 additional hours of post-license education within 18 months following licensure. So you're going to have 18 months to do those 3 classes, 301, 302, 303, right? So one's on agency, one's on law, and one's on working, actually just closing the sale, right? And continuing on from there, contracts. So those are the 3 courses, and you have to do those within 18 months. If you don't do it in 18 months, you're going to go inactive again until they get done. Now, if you go expired, you don't pay the fee at the end of the year, you just let it all go. Reinstatement of an expired license is going to cost you $90. If the license has expired more than 6 months, but less than 2 years, then to reinstate the license will cost $90 plus one of the following: a post-license class or the license exam, all right, both the state and national, or the state license exam if actively licensed in another state, All right. So you're going to have to, if you're more than 6 months, less than 2 years, you got to pay the $90, take a post-licensing class, or take the exam again. Doesn't sound like fun. If you're licensed in another state, you can just come and take the state exam. The Real Estate Commission will require any and all post-licensing courses not taken within the previous 2 years to be completed and file a reinstatement application. Okay. Post-licensing classes expire after 2 years. Here's the key sentence here. If expired more than 2 years, you'll be treated as if you never had a license, which means you're back here seeing me, going through the same 75 hours, taking the same test, going and then taking the PSI test again, starting all over again. So if you expired more than 2 years, you start all over again. All right, display of license. We're all going to get a pocket card, right? You can either do it electronically or you'll get a fit. You can print it, carry it, right? And that would be your proof. When you do, I did a continuing ed class yesterday morning. I had to put in my license number every time I came back from the break. And you'll be required to do the same thing. Some educators will make you show that license. You put it on your phone, take a picture of it, and show it, all right? So it's a proof of licensure. Your firm's going to have to prominently display their license. All right. Brokers in charge have to display their license in their office. Licensees shall notify the Real Estate Commission in writing within 10 days any change in personal name, firm name, trade name, anything. Trade or assumed names must be filed with the Registrar of Deeds in your county. So you're going to get information from your Secretary of State, and then you're going to register it with the Register of Deeds, all right? And a copy of the certificate is going to give it to the Real Estate Commission. Provisional brokers must be under the supervision of a broker in charge, and the Real Estate Commission must be notified. If the provisional broker leaves the firm, the BIC must notify the Real Estate Commission. Brokers do not have to be supervised. Regular full brokers do not have to be supervised by a broker in charge, okay? Now, let's look at the word supervised. The broker in charge still has to make sure the flock is doing nothing illegal, okay? The provisional broker has to work hand in hand with the broker in charge. A full broker does their own thing as long as it's within the realms of the law. And the broker in charge must make sure that they're filling out contracts correctly. They're, doing all of the things that are within the holes of the law. But they don't have to work. They don't have to be overly supervised by a broker in charge. Broker in charge is responsible for the contracts getting filled out correctly. Contracts being filled out correctly has become less and less an issue because now we do a lot of things electronically, and we don't have to worry about brokers' handwriting. Every real estate agent in the world always wants to write like a doctor, and you can't understand the word that they're writing. We've had more misinterpretations by paralegals and attorneys than you care to imagine. Now, we do everything by typing, much neater. You can do point and click. Problems have been reduced by 90%. We talked about this a little earlier, blind ads. You have to put the firm's name, all right? An ad that does not indicate that the property is listed with a broker or a firm, all right? The firm's name must be in the ad, all right? The broker in charge is responsible for all ads, and if you're a provisional broker, you need the consent of your broker in charge to place that ad. It has to be reviewed by them. And you can't advertise or put a sign in the yard unless you have a signed listing agreement. You have to have a signed listing agreement. All right, so some of this we've done already. Copies of all instruments delivered as soon as possible, but no later than 3 days. You're on your own if you're going to wait. Things happen. Nothing good happens when you're waiting. Only bad. You might break even, something bad might happen. Nothing great happens if you're waiting. Do it now, right? But you have up till 3 days to deliver those instruments. Copies of the closing statement have to be delivered at the closing or no later than 3 days. Property managers may be relieved of the duty to deliver records every month with written authority from the principal. If I own a property and I'm the owner, and let's say Earnest is the property manager, I don't want documents every month. Maybe I have a deal with him that says just once a quarter, let's sit down for half an hour and reconcile, right? Maybe I'm busy. Maybe he's busy, right? So we don't want all this overkill. We don't have to if we don't need to. So maybe we can do it once a quarter. So we have the ability to review those documents once a quarter, once every 6 months, whatever we agree to. We have to keep all records for 3 years from the last time we work with them, whether it's successful or unsuccessful. We have to keep that the records for 3 years. Or the release of funds, whichever is later. Ultimately, all listing agreements, all agency agreements must be in writing. Even our buyer's agency agreement, if we're going to present an offer, we need to get it in writing, right? Before we get there. Listing agreements from the inception, from the very start. We talked about buyer's agency agreements, can be verbal at first, if non-exclusive. Dual agency can be verbal at first with the buyer, as long as the buyer's agency is verbal. Let's see what else we need to know there. No automatic renewal. There's no such thing. A property manager can have an automatic renewal in a contract. In our listing agreements and our buyer's agency agreements, there is a hard and fast dead date, a termination date, expired date, same thing. If we want to extend that, we can do an extension form and physically extend it. We can't automatically renew it. Not allowed, all right? Property managers can automatically renew. Sales contracts cannot. And this is our non-discrimination agreement right here. And it says all agency agreements must contain words, the broker shall conduct all brokerage activities in regard to this agreement without respect to race, color, religion, sex, national origin, handicap, or familial status of any buyer, prospective buyer, seller, or prospective seller. Okay, so that's right there. That is our disclosure, our non-discrimination disclosure. Okay, broker in charge. Any questions so far? Anybody? I know I'm going through some of this quick. We've been through a lot of it. I just wanted to remind it. I'm giving it to you. You already have it. All right. So you can read it and make your notes on your own. All right. You can only be broker in charge at one physical location, and every location has to have a broker in charge. Supervise all provisional brokers. Make sure that all the licensees carry pocket cards to broker in charge. All right. Notify real estate commission of change of address within 10 days. Broker in charge responsible for all the advertising. We've talked about that. Trust accounts. All records according to the real estate commission rules. All right. This is fun. Causes for license suspension and revocation. There are lists. And then there is the final one, which says any other violation of license law, which means anything else they can possibly find. If you obtain a license by misrepresentation, embezzlement, fraud, forgery, license law while leasing or selling your own property, violating it, you have to abide by license law. Violation by brokers, unlicensed employee. If your employee shows property for sale, you can lose your license or be suspended. All right. Willful, negligent misrepresentation or omission, making false promises. Agents or advertising, misrepresentation or false promises through agents or advertising, acting for more than one party without consent of all parties. This is undisclosed dual agency. Undisclosed dual agency is a violation of the law. You cannot do that. Must be disclosed. Provisional broker accepting compensation from other than the broker in charge. You have to get paid through your broker in charge. Provisional broker representing other than his own broker in charge without permission. Can't work with another company. You have to work for your own. Failing to account for funds entrusted to you. That's a big one. All right, you have to account for those. Incompetent in your actions as an agent that endangers the public interest. That's your reasonable skill and care. Paying consideration to unlicensed persons. An unlicensed person cannot get paid based on your commission. An unlicensed person can get paid hourly, or they can get paid a flat fee, but they may not get paid based on your commission. Not allowed. Dishonest dealing, practicing law, you can get in trouble. Commingling funds, put your money in with the trust money, can't do that. You're allowed how much? $100, right? $100, that's it. Failure to timely deliver contracts, failure to timely deliver CDs, HUD ones, same thing, settlement sheets, different. Bouncing it, oh, here's one. Bouncing a check with the North Carolina Real Estate Commission. If you send a check to the Real Estate Commission and it bounces, that's a violation of Real Estate Commission law. And they can suspend your license or revoke your license or do whatever they need to, right? So you may not bounce a check, right? That would be up to, they'd certainly ask you questions and they could suspend your license, right? And then any other violation of license law. So don't bounce a check. All right, Real Estate Commission versus the courts. The commission, only the commission can take your license, but they can't fine you. The courts can fine, imprison, or recommend license revocation. Now, if the court says that the Real Estate Commission should revoke your license, is the Real Estate Commission going to say, nah, I don't think so. They're pretty good people. I don't think so. I think they're going to take your license if the court says take your license, right? Now, violation of GS 93A is a criminal offense. Remember that we said the North Carolina Real Estate Commission is 93A? That's how they were created. So this is any law you break or any rule that you break inside the Real Estate Commission rules is a criminal offense. It's a catch-all. So they can parade you in front of a judge. Note to selves, don't do that. Nobody's going to get in trouble, all right? Don't do it. Just do your thing. You'll all be fine. Don't panic, right? Any licensee convicted of a felony or misdemeanor or who receives disciplinary action from a governmental agency must report this to the Real Estate Commission within 60 days of the final judgment. 60 days. Timeshares. We have almost a whole page of timeshares. All right. You need a license to sell timeshares. You have to have a certificate of registration from the Real Estate Commission. And here's our rules of 5, right? 5 or more separate time periods over 5 years, 5-day right of rescission from the contract date. Statement that recordation of the title is possible. They can record the title. Any other Real Estate Commission, any other information Real Estate Commission requires. Public offering statement must contain a 1-page summary. Does not have to disclose the number of timeshares sold, and purchaser must receive the statement no later than contract signing. So the public offering statement, they has to get it before they sign the contract. New will. 10 days of escrow or until canceled. If the public offering statement is not provided, the purchaser is entitled to 10% of the sales price, up to a $3,000 maximum. So before we sign a contract, we're going to have to get that public offering statement. If we don't get it, we can get our money. Must have a project broker designated by the developer. Timeshare registrations cost $1,000, payable to the Real Estate Commission, and renewals are $750. It's real money. All right, and they must have a timeshare registrar who records instruments and releases. All right. Offering timeshares without first registering is a felony. Felony, not a good thing. If you are the licensee and you violate the license law, the licensees can get a reprimand, censure, suspension, or revocation. And developers, all right, if they can be reprimanded, censured, $500 per violation, suspended or revoked, right? They don't want that. They don't want that. All right, so that's timeshares in a nutshell. Trust funds, again, any other people's money. Just remember the trust funds are other people's money and you have to take care of it. You're giving it to hold, all right? So we have to take care of this, right? We are responsible to put it in there in 3 days. We have 3 days if it's cash. We have 3 days from ratification of the contract if it's a check, all right? So separate account All right, has to be a trust account, cannot be a credit union, may not be a credit union. No commingling. You can't put your money and their money together. You got to keep your money out. You can keep $100 in that trust account. $100. That's for check fees and things of that nature. That's it. And you have to have a FDIC insured for at least $250,000 a client, and it has to be ready for immediate withdrawal. Federally insured banks, no credit unions. We know about a provisional broker cannot be responsible for maintaining a trust account. $100 in money we talked about. Trust accounts can bear interest. We'll see in the contract that the clients are going to agree that the broker is going to keep that. We can have a bookkeeper assign, maintain the deposit, but the responsibility is still on the broker in charge. All right, let's see what else. I just told you about when to deposit the money, when and how to disperse the earnest money. All right. If the offer is not accepted, contract is not satisfied by the breach. All right, we can return it. We need to be able to dispute it. And here's it. What about a dispute? If the buyer and seller are disputing who gets the earnest money, in the event of a dispute between the buyer and seller, the broker must hold the money until a written release is obtained from both parties or until disbursement is ordered by the court. If both parties don't agree and sign off on a document as to who gets the money, I have to hold it. I have to hold that money in my trust account. Once that they say, no, we're not going to do that, I have to go file an interpleader with the court or place the money with the clerk of the court, and then they'll handle it at the courthouse. Let's see, so leases, we didn't get to leases yet, so we'll get to them. All of those. Trust account record keeping, maintained for 3 years, again, separate ledgers for each landlord, reconciled every month, may inspect without notice. All right, that's all of it. All right, please print this out, reread it, study it. Same thing with those, with that PowerPoint. All right, same thing with that PowerPoint.
If you like this video, feel free to share it with a friend. For more real estate education content, please subscribe to the channel. From all of us at Seacoast Real Estate Academy, thank you for watching.